Hi, I'm Mike McCabe, and with me is my partner Emil Ali of McCabe Ali. And we're going to like to talk to you today about three things that attorneys should be considering if they're offered a settlement agreement from OED or have to face the decision on whether to take a disciplinary matter to trial. Emil, you've represented many clients before the Office of Enrollment and Discipline. What are some of your top concerns when you're faced with a position with a client who either has the choice of either taking their case to trial or agreeing to a settlement with OED?
That's a really good but tough question. So I think first and foremost, the best way to say it is the deck is stacked against you, right? Going to trial in any sort of position is rolling the dice. Maybe a good tactic for some people, but remember, you have to win on each and every count. So if you can imagine that the way these complaints are drafted and these trials proceed is that you have multiple individual charges for the same count or the same conduct. So with one set of operative facts, you may be charged 5, 10, 15 different ethics rules, and you may win. Let's say you were charged 15 ethics rules. You may win on every single one of those ethics rules, maybe 14 out of 15. And then all of a sudden, you lose on one. That one ethics rule gets you the sanction. And that's the problem, right? And on the other hand, there's also just an enormous amount of resources, right? On our team, we have a few attorneys. We have our client, who's also generally an attorney or practitioner. We have some great people, but so do they. But beyond that, they have attorneys dedicated to the case, not just one, sometimes two or three. They have seemingly unlimited amounts of resources. I mean, they could spend hundreds of thousands of dollars on litigating a case against you and then appealing it and then going through all this process, hiring experts. Some of those experts work for them, right? Those are some really, really key factors that make it a difficult decision.
Yeah, so when you settle a case with OED, I mean, what are you actually doing? Is everybody just walking away and saying that, well, when we're settling, what does that mean? What does that actually look like?
Yeah, that's itself a topic that we could talk about for hours, right? Because as you know, settlement is an admission. I mean, I think the way you probably put it is brilliant because when you compare it to civil litigation, you've done a lot of civil litigation. So when you compare it to civil litigation, people walk away sometimes happy or at least content that somebody maybe exchanged some money or maybe they don't exchange money and we just walk away. No one admits anything. But why don't you walk us through what it's like in OED land?
So in the OED's version of a settlement is that it's more like a criminal settlement than it is a civil settlement. In a civil settlement, as Emil said, people essentially walk away and no one concedes liability. In an OED settlement, there is an admission of liability. OED won't settle the matter without an admission of liability. So they're expecting to see an admission of misconduct that the attorney is admitting that they have violated a certain number, one or more of the USPTO's rules of professional conduct. And they're also agreeing and stipulating to a set of facts, as well as the ultimate disposition of the matter. The facts applied to the law equal this disposition in this case. And that's the settlement construct. It's not just we're settling and we're walking away from the matter. So if one goes into OED thinking, I want to settle, they're not going to walk away for something that's inconsequential. Also, clients will frequently say, well, we want to settle, but we want to only settle for a private reprimand or a warning letter. And that's the only thing that they would accept for a settlement. But OED doesn't accept warning letters or private reprimands as settlement terms. So that's not even going to be on the table for you. They're going to be looking for the attorney to either accept either a reprimand or a suspension of some period of time, which could be up to as long as 5 years. And a 5-year suspension is also what we call an exclusion. So that's a very important aspect of what the settlement is. It's not going to resolve itself by some sort of a um, resolution that no one will know about. Not only will it be publicized, it will be posted on the OED website and it will be published in the USPTO's official gazette, which is the official publication of the USPTO. And now they're also being published on Lexis. And so what are the other options that an attorney has if they're left with the choice of either, well, you can fight and litigate, or you can settle and hopefully live with what you got? Is there another option?
So interestingly enough, everyone always says, I just want to resign. They'll say, Emil, tell the USPTO I'm never going to file a patent again, or I'm never going to file a trademark.
Well, that seems like it should work.
It does, except there's one small problem, right? We call that exclusion on consent. And exclusion on consent is this idea that you're giving up your license, but during the pendency of a disciplinary investigation or litigation. And if you do that, you are essentially saying that I don't admit this, but for purposes of reinstatement, I am admitting that I could not overcome these allegations. And that's a problem, because one of the reasons that, we're dealing with these clients is because they're asking us to help them with an OED issue to avoid that reciprocal harm. Because if you get disciplined at the USPTO, you're almost 100% likely to get disciplined by your state bar. So it's very important for patent attorneys, trademark attorneys, maybe less so for patent agents. But I think that's really one of the, when I look at an exclusion on consent, I think about that, but I also think about it this way. I say it's self-disbarment. And sometimes that may be an appropriate outcome, but sometimes it may not be an appropriate outcome.
Now, when we're saying a summary disbarment, are you saying that another state will treat your exclusion on consent or your resignation from the patent office as if you were disbarred from the patent office?
That's correct. Yeah. So a lot of times, and of course, the USPTO views it that way as well. So if you take an exclusion at your state bar, I think there's a really interesting case called McCabe Ali, who's a Washington attorney that did that. He actually took some sort of an exclusion in the state of Washington. He thought, thinking that, hey, I can just become a patent agent. The USPTO reciprocally disbarred him. And many states do the same thing, right? The states will look at this and say, you know what? This person gave up their license because they couldn't defend themselves based on this conduct. They probably thought that they were going to get disbarred. So you know what? We should disbar them anyways. And that's a problem.
So not an easy way to quit and get out of it.
Exactly.
Thank you for joining us on this next version of IP Ethics and Insights.